Vikas Singh is a senior advocate in the Supreme Court of India, former Additional Solicitor General. Mr. Singh, from what you can see in the public eye, how strong, according to you, is the evidence against the Delhi Chief Minister in the Liquorgate case?
Well, to be honest, I have not seen the evidence, but whatever I have read about this case so far, according to me, there has been political funding. Whether the ED will be able to prove it or not is a separate matter altogether. But there is no personal corruption. There is a political funding, which we all know every political party does. But according to me, there is no case made out for his arrest because every citizen has a right to remain silent and to not answer questions if he feels that that question is likely to implicate him.
No, but here's my specific question. How much credence would you give to the statements of an approver who, for the first several times when he's asked the question about the linkage with Arvind Kejriwal, says nothing, after he's arrested and in custody of the Enforcement Directorate, later says that he was part of a meeting and Kejriwal facilitated the scam, but this person is an approver. How much credence would you lay to statements made by approvers, given that they clearly have a vested interest and that they'd like to do and say whatever to get bail and to ensure that the agency gets off their back?
So as far as, statement of anybody while in custody is concerned, it is of no consequence, no use in a trial. And a trial judge will not even look at it. I mean, you may use it today for the purpose of denying him bail, but this is not something which can be said to be admissible in evidence.
You're saying that these approver testimonies don't really stand for much in court?
No, unless he continues to make that statement when the trial goes. So this is a statement which has been made to the police while in custody. So really speaking, this statement made today.
But if he says the same thing in court, then it has consequence.
No, even if he says this in court, he is also a co-accused. So it doesn't have that kind of evidentiary value to, convict somebody.
No, but the other thing in this case is that if you look at the purchase record of electoral bonds of someone like a Sarath Reddy, when he is not arrested between April 21 and October 22, he's buying bonds for the BRS, the BJP and the TDP. Then he gets arrested. Then he's only buying bonds for the BJP. After he turns approver on June 1, 2023, all the bonds that he bought, 25 crore rupees of them, are only for the BJP. Now that by itself doesn't mean anything, doesn't suggest anything. But when you look at it together, you wonder, dal mein kuch kala hai. Now earlier he's buying bonds for everyone. After turning approver, after being arrested, he's only buying bonds for one party.
So, I mean, that is something which is, the answer is in your question itself. I really don't need to answer that question because, if this the person is buying a bond of a political party which is controlling the ED directly, then definitely that also will, show that there is something more than what meets the eye. But
can the government prosecution get away by saying, "Humne nahi bola, ye to khud hi kar raha tha. Like, we didn't ask him to buy these bonds. He thought he can buy these bonds and buy protection." Because they can also defend it, saying, "We didn't ask him to buy these bonds. He's gotten bought of themselves. How are you blaming us? We never asked him to buy these bonds."
No, so as far as the evidentiary value of buying these bonds are concerned, it is only a circumstantial evidence which the trial judge, when a trial judge examines a matter in totality, he has to look at every evidence and he has to realize or take a call whether the ocular evidence which has come before him and the circumstances under which the evidence comes, whether it is all credible or not. So this will also go against the credibility of the witness, which he says after. And that's why I said that his statement, even if he goes ultimately in court and makes this statement, this circumstance will definitely, attach a lack of credibility towards his evidence. So that his evidence per se or on its own cannot be used for conviction of somebody. So all this will go in favor of Kejriwal as far as the trial is concerned. And according to me, whatever I have heard so far, the money trail has not been established completely in the sense that the donor is there, sender is there, but there is no recipient who has received the money. So unless that stitching up happens, There is no, so the only disadvantage or the suffering that Mr. Kejriwal will have to go through is this arrest which he is going through now, which according to me is completely illegal. Because if he had to destroy any evidence, he would have destroyed that by now already, because he was out for this. This matter has been out in the open for a very long time. So there is no question of him remaining out and destroying any evidence.
So that's
the rest of the evidence is all mostly document based, or which is already collected by the agencies, and he has a right of silence. So you can't say that because he's not cooperating with the investigation, he needs to be kept in custody, because that will be completely violating his fundamental right guaranteed under Article 20, subclause 3 of the Constitution of India. So I don't see this trial really going anywhere except for the short run of,
No, but the short run is when there's an election campaign going on as well, and you've basically knocked the Delhi Chief Minister out of the electoral contest. That's Vikas Singh, President of the Supreme Court Bar Association, former Additional Solicitor General from 2005-2008, very clear in his words. And I'll just leave it to our viewers to determine what they make of what Vikas Singh and the others have said on this show.